I think you can start presenting.
Yeah, I'm starting. Yeah. My screen is visible?
Yes, yes.
Okay.
Yes, it is visible.
Right.
So we'll start in another few minutes.
Oh, yeah.
Previous will introduce the topic as well as the speaker.
Okay.
Then we can you can start your webinar.
Sure, sir.
Okay. Maybe another 2-3 minutes. We'll wait for
yeah.
a few more people to join.
Sure.
And meanwhile, we have started that YouTube streaming is just started.
Right.
So some people will be joining through YouTube.
Right.
Okay. Previous, can we start?
Yes, sir, we'll start. Dear participants, good evening. IEEE CS Madras, ECM Chennai, and CSC Chennai chapters cordially invite you to a webinar on data privacy trends and challenges in compliance by Mr. Ramkumar Ramachandran, founder and principal consultant, Ascentant Corporation. Data privacy has become the de facto requirement to do business in various geographies. Data breaches can seriously damage a company's reputation and brand value. Logically, data privacy should lead to better safety of personal data. But ironically, the opposite is happening. This session is going to broadly address the evolution of data privacy and the challenges that it is currently facing. Data privacy is an evolving subject with more learnings that would keep coming based on breaches and more tweaking of the laws. This makes it important to constantly update our knowledge on various geographies' privacy laws. This session will explain the salient features of various data privacy models, including GDPR, CCPA, Indian PDP, Singapore PDP, FIC DP law. This session would be useful for people who are into InfoSec, cyber law, data controllers, data processors, etc. Mr. Ramkumar Ramachandran is a veteran in the IT industry with global service delivery experience across 10 plus countries, which includes US, UK, France, China, Singapore, Malaysia, Indonesia, Thailand, Taiwan, Philippines, Kuwait, Bahrain, Qatar, Saudi, Sri Lanka, Bhutan, etc. He is an IIM Calcutta alumni, a qualified PMP, CISA, CSQA, and CDPSC. He is also a lead auditor for QMS, ISMS, BCMS, and IDSM. Mr. Ram is a certified systems thinker from MIT Sloan Institute of Management. He provides services in the areas of information security, data privacy, agile, DevOps, CMMI, and ISO standards. He is the past president of Spin Chennai and continues to be on its board. Mr. runs his own consulting firm, Ascentant Corporation, which is primarily into IT consulting. Prior to this, he has worked with HCL, Polaris, KPMG, Renault, Nissan. He started his career as a programmer and then held various responsibilities in the software industry. He later moved into software quality and security. He has taken many organizations into successful ISO and CMMI journeys. Over to Mr. Ramkumar. Thank you.
Thank you, sir. So, good evening, everybody. Welcome you all for this session from IEEE on data privacy. Before I start, I'd like to thank IEEE and my mentor, Shri HR Mohan. He has been giving me a lot of opportunity. I should thank for that. I'm very glad that I'm in this forum to present this topic on data privacy. Okay, these things has been more my passion. Okay, I should call like that. When I first had the taste of info security, it was just a budding field. I'm talking about year 2000. Okay, at that point in time, security was not a real big thing. I mean, now it is so big that it's a big ticket point. But in 2000, when I took up my CISA certification, it was just another field, and then it was important, but not in the scale what it is now. So that's how I got into it out of my curiosity. Later, and specifically branching into data privacy happened 4 years before, when the GDPR, 2016, when they announced the GDPR. I was wondering what this is all about, and then tried to have a deeper understanding. And I have published articles in LinkedIn. I have taken sessions on GDPR specifically, to Spin Chennai and all that, and various other forums. So, point is, I came in primarily out of my curiosity and then stayed by choice. So, now the InfoSec and the data privacy has become my primary area of service delivery. So, I'm glad that I made these accidental choices, probably, with the God's will. Okay. Now, let me go ahead. See, this session is going to be on the breadth and a little bit of a depth. Okay, the depth I'm trying to have limited because if you go into depth on a given topic on one privacy law, that could consume quite a lot of time. So, to give a taste of the privacy law, I'm trying to cover various privacy laws, starting from GDPR. That's primary, the most comprehensive privacy law created, and others are only trying to simulate it. Okay, copy and then try to enhance further and all that. So I'll be covering GDPR and then the CCP for the American thing. And CCP again is being replicated in many states of US. So we shall talk about that as well. The Indian PDP bill, which is becoming active later, and then the Singapore and Dubai privacy laws. So these are broad ones I'm covering. Okay, every country these days has got their own privacy law, and predominantly they try to take it from the GDPR. That's one good thing about it. So if you get a good hold of the GDPR, you'll be able to fairly implement the other privacy laws with ease. Okay. That's the point. So, I mean, you heard about me. So, I'm this. I run my own consulting firm, Ascentant Corporation. I've been to various countries providing these services. Okay, I'm an aeronautical engineer with the Alumni of IIM Kolkata, the medicine school system thinking thing. And then I'm a qualified CSK, CSR, PMP, LDC, PSC, and lead author for these things. So this is my profile. So now, first, before I start, I want to tell about this Infosys study done last year. Okay, now, this is a pre-COVID study. So which means with the advent of COVID, the criticality of the info security has only gone up. Okay, so what this study tells, I mean, it's a very comprehensive one. You could see 1867 people across 847 entities, 847 different enterprises in 12 industries they chose. Okay, and each one had a turnover of $500 million. And that is the way. These are all big entities, okay, for whom the business this is very rarely book and probably transcontinental. And then they were all across this US, Europe, Australia, New Zealand geographies. And when this was studied, the outcome was very obvious. I mean, no surprises in that when people told info security is important. But this is the type of people who were, contacted for this survey. And this is called as Assuring Digital Cluster, led by the Infosys Knowledge Institute. Okay. It also tells broadly that the understanding at the board level is increasing because the penalty is more laid on the board, not on the operational folks. Something when there's a breach, okay, the breach, the penalty for that breach, is more impacting the board. Okay, so now the thought of addressing the securities, info security issues, and the privacy issues is increasing amongst the seniors. So that's one good outcome that the study tells. And it also tells that amongst the corporate boards, 48% of the corporate board are seriously talking about cybersecurity. And among the business leaders, this is CEO, CXO profiles. Among them, 63% are talking about the info security. That's the biggest advantage. Okay. No, that is a volume that is told, in terms of people talking about this subject, and that tells how serious they are. Why this matters? Because at least personally, I know how things are transformed. A decade before, 10 years before, if someone is going to ask, a senior management person or the board people, have you implemented information security? The response could be as simple as, yeah, of course, I think we have a good antivirus. And probably my title takes a firewall also, things of that sort. Antivirus, probably the firewall was all the info security initiative the board could feel about. Okay, but nowadays it's not the case because seen as an operational issue, now it's seen as a strategic issue. And now with the COVID onset, now the different types of attacks are happening, and you'll be seeing every other day. And as a trend, what I've been telling in various forums, and I repeat here, is that for whatever reasons, a lot of Indian corporates are being targeted consistently. There are a lot of biggies in the in India-based entities, not operations in India, just that, but the organizations that have been formed in India, they are being targeted a lot. Okay, that's one trend coming up. Now, the concerns, what they have got amongst the survey, the info survey tells that at least 75% of the people feel that amongst various concerns, corporate espionage was one of the primary concerns that they got. Okay. And very interestingly, they also try to see the insider threats. Remember, many times the insider threat is something which is not understood properly. People always feel, okay, there's going to be one hacker who's sitting outside the office, outside the official network sort of, and then try to attack the network. No. But the study tells that the insider threats are equally important. There are people, insider threat doesn't mean someone could intentionally attack their own network, but sometimes unintentionally, not knowing what they're doing, even that happens. So insider threat is also equally important as could be external threat. And one of the very interesting things coming out is the low security awareness amongst employees. Why is awareness important? As I keep telling, the awareness is a starting point for anything on the info security even to be prevented. Okay, because sometimes the employees do certain activity without knowing implication. So, a mail comes, these days a better awareness, but see, even a couple of years before, a mail coming telling that you won, 10 million pounds lottery, people happily click the link. Okay, someone tells that your password has been modified, they happily click the link. Now, the awareness on these things can be phishing mails has to be given to all the employees, things like that, all the awareness. Only with the awareness, there's increased security. And remember, even one employee, okay, who is not aware could impact the entire organization. Okay, and that's what is called as the strength of a chain is only as good as the weakest link. One link that can be weak could break the entire chain. So that's everything, sir. And the last one, the popular thing is the hackers and the activists. Activists are the one who is intentionally trying to create trouble for organization, not necessarily for monetary purposes, but you want to bring down the reputation. So these are called as the top concerns. So I'm putting this at the start because to tell the importance of the information security and privacy in the minds of the people, in the minds of the corporates. Okay, this is the important, and it's a good sign. Early days it wasn't there. In fact, when I did my University Directors session, my dissertation was on the the board's sensibility on the info security. How should I sensitize the board on the security measures? So that was my dissertation. So definitely the seniors thinking right about this will help a lot to bring in strong initiatives across the corporates. Now, a few breaches, very interesting breaches. Equifax is one of them. Okay, it happened. Equifax, as you would know, is a credit bureau. Okay, like the equivalent of CIBIL in India. So Equifax has got huge data about the credit rating of various people, and the hackers gained information about 143 million Equifax customers. Oh, that is the scale. Okay, 143 million, and the reason is very interesting. And this has been happening more than a year, something like 14 months. This compromise has been happening, the breach has been happening, but then it was accidentally noticed later on. So what was gained? All their name, date of birth, all their driver license number, social security number, all this was stolen. Which means the people who stole it have got everything in their hands about the individual. More than 200,000 credit card numbers were compromised. 182,000 personally identified information, which means this information could help any individual to identify who this person was. Okay, so to that is a volume, and this made the Equifax CEO Richard Smith to testify 4 times at least before the Congress, telling them why it went wrong, what did they do, how are you going to fix it, things like that. He has made answer before the Congress, and the best part comes the last. It was sort of a careless breach, okay, which means there was one struts vulnerability which was known, and they should address the patch. The patch was not installed, and thereby all this happened. Okay, let's just understand that this is one guy, one junior guy somewhere who was not aware of putting the patch on time. Okay, and that patch not put on time led to all this problem. Okay, so that is this. And the current status in July 2019, they reached a record-breaking settlement. Okay, the FTC, Federal Trade Commission, where they paid their total penalties around $1.38 billion, and each person would get something around $135 because of breach. So this is the status as of now for the Equifax. And then comes the traveler. This happened less than a year, sometime the last year, okay, December 31st and Jan 1st, 2020, sort of time. Okay, so the hackers attacked and brought down Travelex network. For whatever reasons, Travelex never told about the breach outside the world immediately. They took down the websites of 30 countries where they're operating, and only told that no, there's some virus and then they're trying to protect data. Oh, very broad, very hazy things were told. They did not tell what is actually going wrong behind. Okay. Then when the attackers came out and started telling, hey, look at it, we have breached Travelex, we got this data. Only then the world knew it. Okay, and there's a ransomware gang called Sudnokibi, okay, who informed BBC, telling that we are asking $6 million as a ransom. Okay, well then the world knew that something was going wrong. And there are a few entities like this, Sudnokibi, Revil, and quite a few. These keeps changing. New gangs keep coming up. They claim that they have got the access to companies. It was 6 months ago. Okay, 6 months they are active. Early case of Equifax around 14 months, and Travelex was like 6 months. And then 5 GB of sensitive customer data has been downloaded by them. Okay, so that is a real big deal. And all the information like your date of birth, your credit card, your insurance numbers, that's what they've been taking from these databases. So many times when the breach happens, the organization is not knowing it. I mean, it may be surprising. I mean, we'll be wondering how come a theft of a place is not known by the house owner. Okay, but that's what things happen when the controls are not the right controls. Probably some compromise happens, and then when someone is stealing at the back door, people who don't know, okay, they will be happily living till the thief is going to come and announce. Sometimes it happens like that. There are times where accidentally, in fact, in the Equifax case, what happened was there's an encryption to be done, which was missed out. They didn't renew the license almost this 1 year's time. And when they wanted to renew the encryption software license, then they discovered, how was this happening? They backtracked and accidentally found that there's been some breach happening for the past 14 months. Things like that. So Travelex case was like that also. Now, this is a very interesting development where Travelex financial woes was no surprise because they have a parent company called Finablar in Abu Dhabi. Okay, so just 2 months after this attack that happened, they told there could be 25 million impact on the results. Okay, that could be taking a hit on their top line. Okay, so in spite of cyber insurance that they have. Okay, so probably the cyber insurance did not cover everything. Probably they didn't think that such attack would happen. But in spite of all this, the Finablar announced that there could be an impact of 25 million pounds. Okay, on the results, on the top line. And then was a Sony breach. I'm going to talk, a few breaches to set the context so that people will know how critical they are. The Sony breach happened on the movie database. There was a perception, we don't know if this is right or wrong, there was a perception in North Korea that their premier was wrongly portrayed in one of the Sony movies, and to take a revenge on that. Before even the movie was released, they had a breach happening, and then this movie was stolen. Not just this movie, quite a few movies were stolen. Okay, so in fact, when they were warning, Sony tried to take some measures, telling that no, it is not the way you understand, and we are not trying to attack any individuals and all that. But in spite of that, the breach had happened. Okay, and in 2014, November 12 happened. And the best part was when they stole, they didn't steal only the movies. They also stole certain messages, email messages, a lot of files went off. What became very embarrassing for Sony was some of the communication that the Sony office bearers were sending between them, which was accusing certain key actors in the Hollywood. So that became a real embarrassing thing than even the movie loss. Sony went and released the movie still. Okay, that didn't being stolen. The movie was still released in the cinemas. But what became the real embarrassment was the communication that was stolen from them. The communication had really nasty references to certain big Hollywood actors. And back home here, this is the trend I've been talking about. DRL is the Dr. Reddy's laboratory. So in 22nd October 2020, the servers across the world, UK, US, India, Brazil, Russia, all the servers of DRL, Dr. Reddy's laboratory, was compromised. That's what they told. They're trying to delineate the servers from the outside world. They took appropriate steps. and then they report a ransomware attack. And while this is seen as a measure because they are also coming out of the COVID-19 vaccine, okay, the possibility of the attack was to know about these information. But this is only one part of the bigger picture, where in the recent past, as he initially told, many Indian entities, okay, are undergoing this challenge. Okay, there's a breach happening. DRL is one of them. You had the Bharat Matrimony, you had the Big Basket, you had the Dunzo, okay, we had the Lupin Laboratories. These are all in the media. It's in public domain. Okay, many compromises happening, whatever scale was happening, but it was all announced. The world knew it. Specifically, quite a lot of Indian corporates are being attacked. So it looks like there is some vested interest which is trying to attack the Indian organizations. So for whatever reasons, so it is high time that the corporates in India take care of these things. Definitely, the big corporates have got some system in place. Okay, definitely all these, including the DRL, is not that they don't have any system for security. Probably they have their own processes and all that, and technical controls that is implemented. But beyond that, there is some weakness that is being exploited. So, and as we would know, info security controls are a moving target. What was the best control yesterday is totally vulnerable today. So it is not that we build a control on one day and be happy about it, telling that everything's taken care. Never. Okay, and that strong and excellent control of yesterday is today totally weak and vulnerable. That's the way things are. So we have to constantly keep re-evaluating our risks based on the change in the technologies, based on the geographical developments, based on the customers' expectations. All this has to be known, and then you have to keep re-evaluating the risks and re-evaluating the controls to the risk to mitigate them. So this should be an ongoing exercise. Only then it will be fruitful. Okay, this is one last breach I want to talk about, a consulting firm, which I cannot probably name. So this consulting firm had a breach where the hackers gained a lot of information about the organization, blue chip clients, their username, password, personal details, even certain mails, okay, about their business plans and all that. And this could have gone unnoticed, okay, for quite a moment. It's not like when it was announced, it was just then happening. That's been happening quite a long, because there is one administrator's account which did not have a password change. That's what it's claimed. Okay, and that administrator's account was compromised, and the entire network was breached. Okay, and the impact of such a way were 6 unnamed clients, okay, of the firm have been told that their information has been impacted by the hack. Okay, so the consulting firm went back and told 6 of their clients that there is impact on your data. Okay, the scale of the impact, the type of impact is not being revealed. And this also led to a control where the consulting firm started implementing the two-factor authentication, TFA. Till then, the TFA wasn't there. Because of the breach, they brought in the TFA. So that is one of the developments. And, it also told that, sounds like predominantly US customers, but even UK customers could have an impact, is what being told. Now, breaches are quite a lot. I'm just trying to list out some of them. Whatever list you put, it becomes obsolete in a month's time. New breaches come up. Okay, so the time I'm talking this, maybe some breaches happening somewhere in some part of the world at different scales. Okay, and even the Google that was down a week before is surprise. Okay, there's been something going wrong, and then the Microsoft supply chain problem because of the SolarWinds. Things like that. So these things keep happening, and it becomes very important for organizations to be alert and to build in the appropriate controls. In info security, whatever controls you're investing into, they are all on the probable problems, not the real problems. That's a probable problem. Maybe you're not attacked, maybe you're attacked. Okay, you wouldn't know. But that doesn't mean you can't invest on security. That doesn't mean you also heavily invest on security. So that is called as the optimal security. You should try to see what could happen in the most possible way. Okay, having a possibility of, say, 50%, 70%, 80% sort of thing. Then for those high possibilities, you try to put in the controls so that you have an optimal investment on info security. What is a clear no-no is, please, no one can ever ignore a problem on the info security for their organization. Okay, you have to somewhere get in and put in some controls. But anyone who is going to overlook this problem is going to be, impacted heavily. That's a very high probability. So that should be taken care. Now, the data privacy frameworks. So this becoming important. The privacy frameworks are quite a few, and in fact, this is, as I told, every country has got its own data privacy law, and many of them are compliant with GDPR, and some tweaking also is being done. So I'm going to broadly give an overview on the GDPR, the Indian PDP bill. It's all more act till it's getting delayed. They're trying to tell that this year it will happen. Next year, the parliament is going to come up, and that point in time, the next possible parliament meeting, they'll be putting this. That's what is being told. And then the CCP, the California Consumer Privacy Act, the Singapore PDPA, the Dubai data processing law, and quite a few countries are there. But we'll be focusing on this five. Okay. Now, GDPR overview. The thought on privacy has been there for quite long. It is not totally a new concept. But probably the privacy law has been enhanced to address the technology changes. As we would know, these days, it's more prevalent. As soon as you get into a site, it tells we have cookies, used for so and so purposes. Okay, either you can review the cookies or you can accept it as it is. Sometimes it is a binary. Either you accept or reject. Sometimes people tell, go into settings, you can pick and choose what can be tracked. Okay. These are all developments because of GDPR. Sorry. Prior to GDPR, no one bothered about cookies. No one bothered about the CCTV images. No one bothered about many other form of data. But now the social media and this IoT, this other initiatives in the technology, those things have made a need to enhance the GDPR, addressing the technological development that has happened. So it all started in 1950. Okay, so where they wanted to have a respect for private life. Okay, people felt that my privacy no one should be invading. That's how it all started. Okay, and in Europe, and 1980, the Organization for Economic Cooperation and Development. Okay, they created certain standards. They told what is the data that can be collected and what is a purpose that can be used. Purpose should be told to the data subject prior and then used accordingly. Then it got enhanced in 1995. Where they talked about collect data only for what you require, the minimal collection. Sorry. Whatever you can collect should have a data expiration, which means I collect the data for a cricket match. I can't use it beyond a cricket match. Once the cricket match is done and complete, all the data I took for issuing tickets, okay, I should erase. So I should be very clear telling that I'm collecting data of yours, probably your name, your contact number, period, nothing more. But after collecting this for a cricket match, once the match is over, I should erase all data. This should be the way the data expiration should be set. Okay, it should be fair and lawful processing. Okay, things like this. All this came up in 1995, and 2016 it became the one what it is now. The GDPR came in, and then they gave 2 years for organizations to adapt to GDPR. It was more enhanced than this, where they talked about, as I told, the adapting was predominantly because of the technology upgrades. Okay, new things coming up. They made very clear about the, breach notification, telling that within 72 hours of the breach, the organization should inform the concerned supervisory authority about the breach and all that. It was more strict. The penalty was made more clear. Okay, so things like that got enhanced. So, and what was created in 2016, again, sort of becomes the norm in many geographies for the privacy laws. Now, how does the GDPR thing? I mean, as we know, it's applicable predominantly for the EU citizens, EU residents. Okay, this is a classic thing. Okay, remember, it is not for the citizens of EU. For that matter, any privacy law only talks about the residents, not the citizens. Even someone is residing in the European Union at that point, at a given point in time, and the breach happens on their data, then they can claim a penalty against the organization for breaching their data. Now, the different possibilities are the controller and the processor can be the same organization. what is a control and process? I'll show you shortly a slide. Okay, the entity that is collecting data from the customer and the entity that is processing data at the back end. Okay, so these two are called the controllers in the process. This can be inside the EU and can be the same organization. Okay, where I collect the data and I process data. Sometimes the processor can be an external entity. Okay, within the European Union. Okay, that's a possibility. Now, the third possibility is the processor can be outside the European Union. Okay, that's a possibility. So the controller remains within the EU, and the processor could be also outside the EU or inside the EU. Okay. Then comes certain governmental agencies, which are called as supervisory authorities. For each country, you will have a supervisory authority. So what is a supervisory authority? These are the entities that oversee the implementation and compliance of the privacy law in their country. So, for example, the UK has got something called ICO, Information Commissioner's Office. That is the name of the supervisory authority for UK. UK is no more part of the European Union because of Brexit, but still UK has got its own data processing law. Okay, so things like that. But every country will have the supervisory authority. So that's the way things are. And now the role definition. You can see there's a data controller, the data processor, and the data subject. Data subject is the individual whose data is being used by the data controller. So as an organization, before you use the data, you ask for consent. You ask, can I use this data for so-and-so purposes, for so-and-so period, and it will be done by so-and-so entity, the processor. All this should be declared and then the consent taken. Okay. And then once the consent is given, the data processor provides a service. Okay. Later on, okay, the processing is done by the data processor and then the results are given. Okay, they use it for their analysis. They slice and dice, understand the customer's mindset, and then try to provide solutions based on that. And once the purpose is met, okay, in case it's going to be enhanced purpose, I got the name and number for the cricket match. Now, I think that this guy will be interested probably in a football match as well. Then if you're going to change the scope, you have to go back and take the consent again. Okay, you have to update the consent. Only when they accept it, then you can do the further processing. So these are three distinct entities as per the GDPR. The individual who is the data subject, the data controller who is facing him and collecting data, and the data processor who is going to process the data, either collecting from the controller or on their own. Okay. These are three different entities. Now, GDPR operates on certain principles, and this is a principle which is also driving many other privacy laws. Okay, the moment a GDPR principle or a data privacy principle is being violated, any country imposes a huge penalty. So, what is the principles of this? Lawfulness, fairness, and transparency in collecting data. Okay, whatever data you commit to a certain purpose, and only that gets collected. For example, when I subscribe for a magazine, all that the magazine would want from me is probably my name, the address, okay, my contact number, things like that. Should be a lawful purpose. Okay. Then the purpose limitation. Okay. When I tell I'm doing it for subscription reason, I should never go beyond it. I should not, sell my data should be sold to a third party, and who is coming and approaching me for a car loan or for a vehicle loan, for a home loan, okay, or for things like that. The minimization, as I told in an earlier case, the data minimization tells if it is for subscription, all that you would now to know is the person's name, their physical address, and then the contact number if at all required. That's it, nothing more. But if you see, when you try to subscribe, they ask you a lot of information. They ask, are you self-employed, or you employed in another organization, or you government employee? Okay, what's your salary range? Okay, things like that. Okay, and how big is your family? All those things are asked. That is not required for magazine subscription. So the data minimization is one of the principles. So any organization violating data minimization, trying to collect more information than required, that could lead to a big penalty. Then the accuracy, maintaining the accuracy data. Okay, whatever data you collect should be accurate. And this accuracy is ensured by providing access to data subject. They open this data to the concerned data subject and tell them, hey, look at this. This is your data. Please confirm this right or wrong. So the data subject themselves can correct until this is the right one. The storage limitation, as I told, the data expiration, I should store the data only for the identified period. I should never go beyond it. So that is called a storage limitation. The The data's integrity and confidentiality. I should ensure, because the sensitive data being stored, I should ensure the appropriate controls for that data. This is very, very important. Okay, if the data is breached, then I as a controller or I as a processor will be accountable for that breach. Okay, so maintaining high integrity and confidentiality of the personal data becomes very important. Those are the principles. And then the next important thing coming up in the GDPR, which is again in many of the geography laws, is the rights of the subjects. What are the rights that is given under GDPR? The right to know the information. Okay, the data subject can always ask, what is the data you hold about me? I would like to know. Okay, can be known. Any point the organization cannot object, no, we can't give you, because the owner of this personal data is the individual, not the organization. Right to access. The data subject can always tell, hey, look at it. I know you're holding my data. Can I see access and see what you hold about me? Okay, can be one of the subject rights. The right to rectification. The subject can always tell the data what you hold is wrong. Maybe I want to modify it and then get the access and modify it. That's one of the rights of the data subject. Right to withdraw consent for whatever reason. Even with no reason, they can withdraw consent. Sometimes the consent is more a reactive one. They see that the data is being used for some wrong purposes. They can withdraw consent, or just think that, yes, I told you that you can hold my data for 6 months, but if just 3 months, still I don't want to give my consent. I'm revoking my consent. There should be provisions for this. Remember that if the organization who is collecting data is not providing a mechanism to withdraw consent, then that becomes a problem. Okay, the right to withdraw consent is very important. There should be a mechanism through which the data subject can log into a site or write a letter to them and withdraw the consent. The provision has to be given by the data controller. Right to object. Not telling that you collected my data for a given reason, but now I see something else happening. So they can object, and then they can go ahead and withdraw the consent as well. Okay, it can stay with the objection alone, or with the objection they can go to the withdrawal of consent. Both could happen. The right to automated processing. So now the analytics in place. Okay, the people tell that please don't use any automation to do it. That's the way it's currently happening. But okay, 99.99% the data is sliced and diced by the people, to get the right profile of people for focused marketing. And that is what there's a provision telling. If you're doing automated processing, then please don't include my data. Okay, for all this analytics, okay, my data should never be considered. That could be a point raised by the data subject to the EU clients. And then the right to be forgotten. Okay, the data can reside with you, but then no more processing. Okay, so it's a need to be forgotten. So holding data is your call, I'm fine, but then never process my data. And finally, the portability, the right to port the data, which means I don't want you to process my data anymore. There's another controller, okay, a similar profile. I'd like you to transfer my data to the other controller. Okay, so which means it should be in a portable format. Okay, probably things like a CSV file, things like that, so that, and then even the structure should be the same, so that it becomes a portable one. Countries are defining these portable formats. Okay, still probably the personal data name, and then the number, the SSN number, social number, things of that sort, and then that data can be transferred to another data controller. Okay, that could be a demand raised by the data subjects. So these are the data subject rights, and actually it makes the data subject very, very powerful. All that matters is the data subject should be aware of their rights. The same thing will come into the Indian PDP Act once it is coming. Okay, so how the data subject using these rights is that decides how they're going to invoke a penalty. Now, the GDPR penalties. So, I mean, we've been hearing for this quite long. So, actually, it is in two different categories, a minor breach and a major breach. If it is a minor breach, okay, then it could be 10 million euros, okay, or 2% of the annual turnover, global annual turnover, okay, not just in European Union, okay, global turnover of 2%, whichever is higher, okay, that will be the amount of penalty to be taken. Or if it is a major breach, okay. So what is major, what is minor, we'll see shortly. Okay, if it's a major breach, then 20 million euros, okay, or 4% of the total worldwide turnover of the previous financial year. Okay, this one of them could be the penalties laid. But there's also something which I'll talk shortly. It is not like one number is being applied directly. This is what it starts with. Now they tell major violation. You look at it, you have to pay 20 million euros. Then starts the controls. If you got some controls, they decrease it by 5%. Something more, they decrease by 20%. Something more, they decrease by 30%. Okay, if the controls are in place, then it looks to be unique. Then the entire thing could turn out to be 30-40% of this penalty, what you see here. This is the way they decide. Remember, as I told, the numbers are not just right, but these things are considered before they decide the penalty. First, the nature, gravity, and the duration of infringement. If it is a very new one, okay, it just happened a week before, a month before, okay, then the penalty is lesser. They decrease the penalty. But if it's a long-running breach, people, as I told, the Equifax case, sort of 14 months it was on, they didn't know it, then that could result in a bigger penalty. So they consider that, and then number of data which has been impacted. More people are impacted, bigger is the fine. Okay, that's the one. In fact, this is a very interesting area. Someone who is specializing in privacy law, they also specialize in the cyber legal part of the privacy law, and that could make a great profession actually. And next they try to see whether it's an intentional breach or a negligent one. Okay, so they try to see whether it's something. I mean, because you're aloof, as I told in the case of Equifax, such vulnerability was not fixed, and that led to all this problem. Okay, then that decides. And they also see any action taken by the controller or the processor to mitigate the damage. Okay, in case they are doing that, then to that extent the penalty comes down. The degree of responsibility of the controller or processor, taking into account the technical organization measures implemented. So they look into things, have you encrypted? So if you're encrypted data, to that extent the penalty goes down. Okay, so things like that. Okay, and then any previous infringement of same nature. So some problem has been recurring, but the organization did not bother to fix it. Then that could lead to a bigger penalty. And the degree of, this is very interesting, the degree of cooperation that the organization gives to the supervisory authority. So if you're more cooperative as a controller or processor, if you're more cooperative with the supervisory authority, to that extent, the penalty goes down, telling that yes, they are trying to be open with us and then trying to explain the problem. So let us decrease the penalty. It's a call taken by the supervisory authority. There's a very interesting site. People who are interested know about the GDPR breaches and all that. You can go and check this one, enforcementtracker.com. It gives country-wise breach for the GDPR thing. Okay, telling what is who's the authority. For example, UK, it's the ICO, which is the thing. Okay, on date of breach, what is the fine levied? Okay, for what is the reason behind this and all that. So this is an interesting site that tracks the penalty across the GDPR implementation. So that was the mother of all the privacy law. And now we're getting into this Indian Privacy Protection Bill, GDP 2019. So it started all when the committee set up in July 2017. So Sri Krishna was heading this committee, okay, who presented the first bill in July 2018. Okay, they got a panel of parliament members who are also there. So all together with Sri Krishna heading this. So they first gave the draft on July 2018. And then it was put in the parliament on 11 December 2019. And it was referred to a standing committee the same day. Now, the standing committee report is ready and then should be made as an act. It has been talked earlier date was February 2020. That was the initial plan. When the parliament was going to convene in February 2020, they planned to make this an act. And then by that time, the taste of Corona has started globally. So this took a backseat. And then now, probably next year is what is being told. But there is a delay, and then probably it should come up. But there are a lot of actions happening at the background. Okay, so certain things I'm privy of where people into many governmental agencies are building the infrastructure to implement effective privacy law. It is not just on the paper, but technically also they're enhancing the infrastructure to ensure that there's a proper privacy law implemented. So that includes telecom operators, that TRAI, and many other people are into the race. And shortly, maybe that's what I believe. Okay, shortly, 3 to 6 months time, all the spam SMS that's coming up will be stopped. Okay, so there's a very, very clear guideline enforced where only with certain technical restrictions people can send SMS. Peer contacting people. That's the way things are happening. So if everything goes as per plan, God willing, we will get a real good privacy law implemented in the coming months. Now, the applicability of this PDP bill, okay, as it is told like the EU residents, here also it is talking about the processing of data that has been collected, disclosed, or shared within the territory of India. It's all about the residents of India. Okay, processing the personal data that has a connection with any business, okay, in the territory of India. So, which means even foreign agency operating in India, they become liable to be compliant to the PDP Act once it comes up. So it is like that. And the bill is applicable to the processing of personal data. The same is undertaken by the state or any Indian company or an Indian citizen or persons as per the Indian law. Okay, everyone gets covered. The moment the organization decides to process personal data, immediately the Indian PDP Act will be applicable. Okay, but to be safe, the PDP Act is believed will not change any further. Okay, but we wouldn't know. Only when it takes a final shape and is being announced as an act, the real shape of the PDP Act will be known. Till then, these are the ones that is being told as per the report. Now, the roles in the PDP bill is this: the owner of personal data is data subject. Okay, the individual who is getting this data and the client-facing entity. They are called as the data fiduciary or significant data fiduciary or the guardian data fiduciary. The three different categories. What is called as a data controller, the GDPR perspective, are three different possibilities under the Indian PDP law. And then we are processing data. Okay, the data processor could be a data processor or data sub-processor. Okay, or it could be even a third entity. So the entire supply chain, all of them gets covered in the data processor thing. So this is the roles that is being told. In fact, in the Indian PDP bill, three data are there. One is the personal data, other is the sensitive data, and the third is called as a critical data. Okay, there's one more third category coming up as per the Indian law, which is not there in GDPR. The GDPR gives only two categories: the personal data and the sensitive data. Sensitive could be about person's health, about their political willingness, things like that. But in the Indian PDP bill, they have one more, telling the critical sensitive data. So the third category. But what is the guidelines for third category has not yet been disclosed. The penalties that could happen under the PDP bill as of now, okay, for any minor violation, the maximum could be 5 crores Indian rupees or 2% of the global turnover. And a major violation could be turning out to 15 crores penalty or 4%. So this is in the same shades of GDPR, as you could see. And they also have a lot of subcategories. So it is not just a breach and then a penalty. So something else also leads to a penalty. Any possibility of the failure to address the data subject request, as an individual data subject, they send a request, asking to show the data, what they hold or whatever request. If that is not processed, then there could be a delay of 5,000 rupees for every delayed day. So they set an SLA. For example, if you take the GDPR, we talk about 30 days of SLA, and the 30 days includes the weekends. There are 30 business days, the 30 calendar days by which the request should be addressed. But the same thing, probably the Indian law, they set an SLA, and when the SLA is breached by the data controller, then the penalty could turn out to be 5,000 rupees per day, leading to a maximum of 10 lakhs. Which means 200 days they can violate. Beyond 200, the same 10 lakhs rupees. Failure to furnish reports at 10,000 rupees per day, and failure to comply with the directions in the authority. Okay, so they're also forming an authority, data protection authority in India. Okay, who will give guidelines or directions to the people, to the entities. If that is being violated, then 20,000 per day delayed. Okay, and maximum of 2 crores. So when no other clause applying, which means this is some very unique violation happening, which is not covered in others, then that miscellaneous thing could lead to a maximum of 1 crore penalty to be paid by the data controller of the processor. So, and the best practice, beyond this, they also are applying the CRBC, okay, where they tell the offense is punishable under this act and shall be cognizable and non-bailable. Okay, any violation done and then they don't pay the penalty or whatever. In addition to that, there could be a non-bailable offense. So people could be jailed and then they could not be taking bail. Okay, things like that. So that's and surprisingly, many geographies are not bringing in any jail term for these violations. Okay, that way India is slightly unique. Okay, there are a few other geographies, but then India is also one of them where they give a jail term for any violation of privacy. And then the CCP. CCP is the California Consumer Privacy Act. This is a very interesting development. It was actually a real estate tycoon in California who actually triggered this. In California, the law can be promulgated even by the citizens. It is not that the government should only bring in the new laws, but even the citizens of California can decide to have a law for themselves and then create a vote for that, and then with the requisite votes being got, they can go ahead and roll out the new law. That's possible. Now, that is the way the CCP got triggered. This real estate tycoon used to host parties, and one of the parties, he had a young man from Google who was talking. This is all on record. Everything is on record. No surprises on this. Where this man from Google was talking to this real estate tycoon, and then this guy, real estate tycoon, was asking, "What is the data you hold about us?" Okay, I think it's very, very non-harmful question, and the response he got from this Google guy was so amazing for this tycoon. So he felt, you have so much of data, and then he thought at least his part, the Californians at least should be safeguarded from this privacy invasion, and that is how he made people come together and then create a law. But obviously the technology giants didn't like it because many of their business was happening because of these data being got and then probably sold and then used and all that. So in fact, the consortium was formed by the technology giants to fight against the CCP. Not in the real terms, they wanted to dilute because CCP was imminent. CCP could not be stopped, but then they wanted to dilute certain things of the CCP, and they came together and did this. But there was some problem initially, but now it's getting fixed. I'll talk about it a bit later shortly. So now, who will be applicable, who will be covered under the CCP? Anyone who has got a gross revenue exceeding $25 million per year, okay, annual gross, so they could be covered under CCP. Anyone who is receiving, buying, or transferring more than 50,000 personal data per year, okay, so those entities will also be covered on the CCP, or 50% of the revenue is coming from personal data, by selling personal data, okay. If that's the case, then they also get covered on the CCP. These are the triggers to tell who will be covered under the CCP. The timeline for the CCP is that on 20th June, it all started, okay, first thing. And then we passed it on September 2018. Okay. Now, last year, they had some amendments done, which was really substantive, because one of the very interesting things which I'll put later in the slide is that in case there's a penalty, there's a breach, okay, by one of the data controller, the breach is, once the breach is known to the outside world, if they fix that breach within 30 days, there's no penalty to be paid by them. And that was a call with the earlier CCP version. That's what they're forced to do. But no, that is getting reversed. That is a new change that they made on 9th October. And then it became effective from 1st Jan this year. Okay, now the expansion of scope is happening, and it's happened in November. Okay, they created the CPRA. I'll talk about that. And CPRA comes into effect from 2023. Okay, and the data collected from 1st Jan 2022 will be applicable for this new law. So water data that the Californian residents, when they've been collected, okay, that data of 1st Jan 2022 will be covered under this new law. Okay, and that will be effective from 1st Jan 2023. Oh, this has been the evolution. So this is a real brave step, because initial attempt to nullify the CCP, make it toothless and all that happened. But then now things have become stronger and better, and then these things are happening. So I only pray that this strength continues. Now, what are the implications of non-compliance? Fines are in addition to the loss of goodwill or consumer trust. Okay, so or expenses that could be associated with the compliance. So one is a penalty. If I'm going to tell that because my data was compromised, I had to undergo these expenses, and of course the mental turmoil and all that. So the penalty comes the other expenses should be paid by the organization, the data controllers. Okay, so the fines are something like 2,500 per violation, okay, or 7,500, okay. Intentional violation, something is accidental, something is intentional, so the numbers differ, okay. So it doesn't place a cap on total fines. So then comes the third point, which I have struck out, okay. CCP provided 30 days for remedy, okay. Now with the new development on 11th October 2019, this provision is being removed, okay. This is no more there. So as an example, if for Californian residents, if the 10,000 people who are impacted, okay, the penalty because of this 2,500 per violation could turn to be 25 million, okay, for unintentional and then a violation, or 75 million for intentional one, okay. So this is the example to tell the scale. What could be the penalty laid to the organization? Okay. And something more, if the personal information is not encrypted, okay, which means they didn't know the risk involved, they didn't encrypt the data, then the damage could be between $100 to $73 per resident, okay, per incident, or the actual damage, whatever is higher, okay. So to oversee all the CCP compliance, they are called the CPRA, the California Privacy Protection Agency. This is like a supervisory authority for GDPR, who will be overseeing the compliance of privacy law in California. So the new changes is that earlier, which wasn't there, they can correct their personal data. They can auto geolocation tracking. We know that many things, including Google, has got geo tracking, which means Google knows where we go, how long we stay, which route we take, and all that. So they can opt out of that. Okay, and then they can browse without the pop-ups. Okay, telling them do this, do that, and all that. So these are the new developments that has come with the latest amendment in October 2019. Now, a few other states are following suit in US. So some state which is just mirroring the bill, the CCP, or the Hawaii, Maryland, Massachusetts, Mississippi, Maine, and Nevada. And few states are trying to extend or have their own thing, which is like New York, North Dakota, Washington, Texas, and all that. So these are the ones who are trying to have something of their own. But point is, every state wants to have one on their own. That's the way things are, and this is the way it's going to develop. So going forward, you will have certain set of common privacy law applicable across the country, and certain states would have some tweaking done, okay, based on their requirements. This is a quick comparison of few states, okay, across California, New York, Maryland, Massachusetts, Hawaii, and North Dakota. Everyone has got this right to delete, except North Dakota. Everyone has got right to access, and then right to correct. Only New York has got it right now. The others don't have it. So this tells the tweaking that could be happening across states. So it is not a common law. In fact, when GDPR was also formulated, the thought was the entire European Union will have a common set of privacy law. That was the intent. But what has been seen in the past 2 years is every country is trying to localize the law. Okay, maybe 60% of the GDPR could be applicable. 40% could be something very local. The local thing could happen based on the penalties, based on some derogation they bring in, telling that this is applicable for our country, this is applicable in this region, sort of stuff. So that is coming up. So we have to face this. Okay, there's no choice about it. But point is, these localizations will help them adapt better. So to that extent, localization has to be there as well. So this is a quick comparison of few states. Now, then comes the Singapore Personal Data Protection Act, PDPA. And they've been there for quite long, from October 2012. Okay, so they have a Personal Data Protection Commission, PDPC. Okay, like the Supervisory Authority for GDPR. PDPC is the commission which oversees the compliance in Singapore for this privacy law. Okay, many of them, the enhancement happened recently. Okay, so many of these things are compliant with GDPR. Few exceptions, as I told. Every country tries to have something local to their region. Okay, so there are some exceptions. And the first thing that was done in Singapore is this DNC registry, do not call registry, okay, in 2013. So anyone who wants to contact an individual should first try to know whether that number is there in the DNC registry or not. If it is not there in the DNC registry, then they can go ahead and call this individual. Okay, else they can't. The penalties are very, very huge. Okay, and the new guideline, I mean, PDP, the Singapore PDP also is, they are giving some guidelines, some enhancement on a constant basis. So the last set of things came in 2016, a major change. Okay, and then there was a guidance provided in July 2019, okay, which talked about the data production management program. Okay, they created a program on how the organizations can ensure privacy, and then the new NRIC rules. There is the citizens card that Singapore gives. Okay, was enforced from September 2019. So, like our Indian Aadhaar card or the Social Security number of the US, okay, the NRIC can be collected only by identified entities, and the protection to be given for that NRIC is very, very clearly laid out by the Singapore government. Now, some key components of this Singapore PDP, the DNC, NRIC, and then obligation data subjects. So, first, as I told, any organization wanting to contact first should check the registry and only then contact them. Okay, and then this is the NRIC applies to any permanent or replaceable unique identifiers, not just NRIC card alone. In the Indian context, it's about your Aadhaar card or the PAN card or the passport number, things of that sort. Anything which is unique identifier. Okay, there should be a great level of security to be provided. The organization who are storing such data. Okay. Singapore government provides a non-exhaustive list of organizations that can collect the NRIC number. So it also lays down very clearly that these are entities who have proven their capabilities who can store the data. And the obligations to data subjects, as we saw the data subject rights, the same thing comes over here as well. The consent of collecting data, notification that it's being used, purpose limitation, accuracy of the data collected, protecting the data, retaining for only the identified period, accessing and retention, transfer of data, and accountability. So these are some of the data subject rights in line with the GDPR is being given to the Singapore citizens by the law. So anyone processing Singapore citizens' data should comply to the Singapore PDP. There is some interesting certification that Singapore gives for organizations who are complying to the privacy law, called as the Data Protection Trust Mark. They're given a set of law, and then there are agencies who can come and validate the organization's compliance and provide this mark. This is called a trust mark. So when it's being shown, it's believed that they are complying to this law thoroughly. Okay, so this logo tells that they got a good system in place for safeguarding the personal data. Now, the last one which I want to discuss about is the Dubai Data Protection Law. It came on 1st July 2020, called as the Law of 5. They had this for the Dubai International Finance Center, DAFC. Okay, so the scope is that, and they had a DAFC Law 1 from 2007, and that now gets replaced with Law 5 on 1st July 2020. And then this tells any organization incorporated in the DAFC region, okay, wherever the processing taken place, they should comply to this privacy law. It also applies to companies that they could be incorporated any place. In case you're processing data from DAFC, okay, then they should also comply to the privacy law, data privacy law. Okay, and as I told, even the Dubai privacy law, many places is mirroring GDPR almost like 100%. There are few places which it's different, but then predominantly it is a GDPR compliant law. The new law 5 of July 2020 talks about this. It provides clarity on the applicability. Who, as I told earlier, who will be covered on this law is made very clear, and it increases the data subject rights. Okay, the organization which is collecting data cannot abuse this personal data. So it makes very clear what are the rights of data subjects, so that in case of a breach, then data subjects can go and fight the case with the concerned controllers. It demands a requirement of the DPO, Data Protection Officer. See, this is a very gray area, one of the challenges which I'll discuss shortly. But the Dubai law tells the moment you are processing personal data, you should have a DPO. A DPO need not be a full-time guy. It will be additional responsibility, but someone should be known as the DPO of the organization. And the moment you identify a person as the data protection officer, their information should be available on the website of the organization, so that someone who is facing a breach should know whom to contact. Okay, so this becomes important. And then comes the ROPA, which is called as a processing information. Whatever records you're processing, which records you're processing, the records of these processing activities should be recorded. A log should be maintained telling that this is the type of data and was processed for these purposes. So that should be maintained. And mandatorily data protection impact assessment. DPIA is one of the classic things about the GDPR, where we try to identify what are the assets we hold, what is the purpose of that, what could go wrong in the asset, how do you mitigate that risk. Okay, that is called as DPIA. So that is again mandated by the Dubai privacy law as well. In terms of the joint controllers is a very interesting thing that comes up in GDPR. When the same organization is operating from multiple European countries, say the France, Italy, and Germany, okay, the same corporate that is in 3 countries, they can have a common set of privacy practices, and all these 3 countries can report to a single supervisory authority. Okay, and they are called as joint data controllers. So the same thing is now applicable to the Dubai law as well. And it tells for any online services, the default privacy preferences should be given by the concerned e-commerce site. Okay, it should not be left to the individual, but by the e-commerce site. And the mandatory processing agreement between the controllers and the processors. Sometimes the controller gives a commitment to data subject, and that commitment in turn should be ensured from the data processor. Okay, back-to-back arrangement should be there. So that is called as a data processing agreement between the controller and the processor. So that is becoming a mandatory requirement as per the Dubai privacy law. The penalties are like this: maximum administrative fine of USD 100,000 for any breaches that could be there, and for breaching provisions related to the controller's obligation, okay, to cease processing personal data. They stop, then that could be till USD 75,000. Any failure to comply with the provisions of the data protection law of Dubai, then it's 50,000, and there's no reference to imprisonment. That's a very interesting thing. Like, unlike the Indian law where they talk about imprisonment, Dubai law doesn't talk about imprisonment. And data subjects have the rights to demand compensation for a damage suffered by them. So the subjects can always tell that, because of this, I lost something. My money was stolen from the card. Okay, I lost my reputation. Whatever thing. Okay, they can additionally demand more compensation in case the data is being breached. So these are the penalties that comes to the Dubai privacy law. Now, we've been seeing various privacy laws across the globe. Now, the real challenges, all of a sudden, privacy law, as I could have been told in the write-up of this session, is an evolving one. Okay, it is not like it is matured and people very clearly know what could go right, what could go wrong, and all that. So, without naming a technology giant, I would like to tell one: there was a breach in one of the big technology giants. Okay, and in Europe. So, when the press was asking them, okay, the breach happened almost 3 months, and one of them was reported. When the press was asking the spokesperson of the technology giant, asking, why did you not report this violation? Okay, what stopped you from? Because as per the GDPR compliance, 72 hours is what the time that should be taken within which the breach has to be reported. And this press person asked, why didn't you ever report it? And then this technology giant spokesperson tells, yeah, you're right. But then something was going wrong. We're trying to understand, is it really a breach or not a breach? Okay, so, and that took us 3 months. Now we know it's a breach and now we have reported it. Okay, these are the loopholes that is coming up in the law. So, these things will stabilize only as the penalties come up and all that. So, I'm trying to put certain challenges that is there to contact or not to contact. As a data controller, to contact some prospective customer. Okay, if I contact them without their consent, will there be a problem? Or if I don't contact, how will I run my business? It's a question to be answered. So the point is, the first time a data subject is being contacted, okay, there has to be some mechanism of consent. These days, very creative things are coming up. People get linked on the LinkedIn, networked on LinkedIn, and then that contact becomes the basis of interaction. Then the moment they call for the first time, they will, hey, look at it, you are networked on LinkedIn, so I'd like to talk something about our business to you, or you find. That's how things start. So people are trying to find creative ways of ensuring that there is no privacy impact when they make the first contact. Then buying a third-party database, is it compliant or non-compliant? One of my customers were telling that they had a vendor who was selling databases, claiming that they are GDPR compliant. So now that's a challenge. So the GDPR very clearly states who will process my data should be stated. Okay, if I were the customer, if a personal data subject, and I'm giving my data to a data controller, the data controller should clearly tell this data I'm going to use for these purposes, and these are the people who will be able to access your data. I should make that very clear. Now, the surprise here is someone selling the database. How will they preconceive an idea about whom they're going to sell? Probably the consent should be taken after selling data or before prior to selling data. You should go back to the data subject, saying that, hey, look at it. Your data as a data aggregator, I got it with me and I'm going to sell it to this person for these purposes. So without consent, buying a database is a risk. Okay, that's for sure. And the next challenge is to have a DPO or not to have a DPO. Okay, this is a very classic thing. As per Dubai law, it mandates a DPO has to be there. What is operation? Okay, maybe the organization is just 5-member, 10-member organization. Still, you need someone to identify as a DPO. Okay, but as per GDPR, the DPO is only an option. Okay, data protection officer can be required if there is a huge risk to the personal data that's being stored. Okay, if the data that you store is not sensitive, is very much controlled, then it is fine. So what are the examples? Even a 1,000-member organization, okay, all the personal data that they hold is only of their employees, and all the payroll processing with their employee data they're doing in-house. Then the risk is minimal. They don't require to have a DPO. Okay, so in this example, but another entity of say only 50 people, but they're an analytics company. Okay, doing a lot of slicing, dicing of data and all that. Then in that case, even the organization is small, there's huge risk because they'll be getting quite a lot of data and they have to be compliant to this privacy law. So that is you should have a DPO as well. So even the 50-member instance, a DPO becomes mandatory in an analytics company profile, things like that. Okay, personal data lake versus personal data in the business process. Well, people tell there are analytics companies which also extend their service telling that you'll scan the database, try to identify personal PII, personal identifiable information, and tell you where the risks are and all that. That's one way of the data lake being scanned and then trying to find out. The other way is trying to see various processes of the business that is capturing personal data. So you take up an organization, ask what are different processes that we have. So one could be like your help desk process, other could be a support process, other could be your marketing process, other could be your project management process, things like this. So take into consideration all various business processes, and in that process, are you capturing personal data? Try to identify that. If you're capturing, what type of data are you capturing? Okay, then knowing the type of data being captured, what is the risk to that? Knowing the risk, what is the mitigation to that? So that is another way. I recommend my clients to do a personal data in the business process, not the data lake. Okay, so understand the business process, try to know what are the risks for that, and then try to fix those risks. Okay, that's the way. And next challenge is which is the right privacy law, data privacy law. This is very, very dicey. And actually, there's no choice in this. If you cater to identified geographies, the law of that land will apply to you, period. Okay. If you're operating from India, the Indian PDPA will come in. And if you're catering to European Union or to the US or to Singapore or things like that, okay, then that law, okay, of that country, if there's a privacy law in that country, your service should address that law as well. There's no choice. It is not like, maybe I'll be compliant GDPR. I think that will take care of everything. No. Okay, if there is specific requirements in other geographies, you have to address that law as well. So all the privacy law in the areas of your service, in the geographies of your service, will apply to the organization. Okay, that's understanding. To inform the breach or not to inform. Okay, sometimes, this is very important. Every law has got some defined SLA in which the breaches has to be informed. There is no questions about it. So people should know very clearly what is SLA and how to inform. Sometimes When the breach is on a smaller scale and there is no impact to the individuals, then you can withhold the breach information. You should still have a log of breach and take an action, but you don't require to intimate because there's no impact to any individual. But otherwise, predominantly informing them as per the geography's SLA, which is very, very important. Okay, and the consent by default or explicit. Things like GDPR, okay, even other privacy laws are very, very clear. The consent cannot be by default. Okay, in fact, the GDPR very clearly states the terms and conditions of a service or a product under the consent should never be clubbed. Okay, the terms and conditions has to be separate, where the people could tell I agree and keep going, and separately should be a consent where it tells what is data you're capturing, what's the purpose, who is going to process, how long do you hold it. All that should be separately given and then consent taken. Even that, GDPR is very clear telling it should not be a pre-ticked consent box. Okay, where there is already a ticked and then you just still accept things like that is not acceptable. There should be a conscious consent given by the data subjects on the consent for this personal data. Okay, and then the last one is this: to cooperate with authorities or not cooperation. You saw that in the penalties thing. Better cooperation leads to lesser penalty. So it is always good for organization to give full cooperation. Okay, there is no reason why organization should not cooperate. And if you're going to cooperate, you're going to decrease the penalty. That being the case, a better cooperation is always good for the organization, at least to decrease the impact on the penalty. So how to comply this? As organization, if people are interested in implementing the privacy law, okay, if it is GDPR, you can be certified with GDPR. That's a provision as per section 42 and 43 in GDPR, where you can be certified. Or there's a standard called BS 10012, the British Standard for Privacy. Okay, that could be taken as certification. Or there's a standard ISO 27701, the current one released last year. Okay, so this can be certified. But this 27701 is a delta on 27001. You should be certified for the ISMS, the 27001. The delta could turn out to be the 27701. So that way. So the three different possibilities. And once you put these things, they become the umbrella framework. As you tell, there could be a tweaking required for other laws, including the Indian PDP Act or the Singapore or the CCP anywhere. You implement this and then tweak certain parts alone to comply to the different geographies. This is one mechanism to go about. And quick guideline for the senior management is that understand what is personal data and sensitive data, understand the business flows, understand the compliance requirement of various geographies. Be clear on the contractual commitment that is given to the customers in these geographies. Ensure a strong privacy and governance. Okay, understand the penalties. Okay, engage a third party to test the privacy controls for the resilience, and also consider cyber insurance. This is very important. This is gaining a lot of importance these days. Getting insured for the cyber breaches that could be there. And people who are going to implement data privacy, these are the broad steps. Identify the scope of the data privacy initiative. Identify a governance mechanism for data privacy. Create a culture of privacy in the enterprise. Train the people on data privacy. Understand the flow. Create inventory of the data, the personal or sensitive data we have. Conduct a privacy impact assessment. Define data processing consent mechanisms. How to take a consent. Appointing the DPO, including the privacy risk assessment, and design periodic privacy audit mechanism. These are some ways of implementing data privacy in the organization. So this is all broadly from me. Thanks for your time. Thanks for your patience. I sort of overshot the time given to me. Thanks for bearing with me. The floor is yours.
Thank you, Mr. Ramkumar, for your excellent overview presentation on data privacy related items. Basically, you are given the overview of cyber threats, breaches, and privacy frameworks of various countries, right from GDPR, PDP Bill of India, CCP of California and other states of US, Singapore, Dubai, and then the challenges associated with this Data Privacy Acts, as well as the guidelines to implement. And also, one important aspect that you have covered is the role of top management, how to educate the top management. Basically, the top management And in terms of costs associated with implementing certain regulations, they try to avoid. They
Yeah.
only want to wait and see. If something goes wrong, we can try to cover up the issue or something like that. So basically, that cost consideration, it puts them off. So you have very vividly brought in the nature of role of top management in educating them about the importance of this Data Privacy Act and then how to make compliance. It is excellent. So I would like to thank you very much for your overview presentation, which has been a really knowledge sharing session for many of us. Many of us are not knowing so much in detail, and in a single 1.5 hour session, you have brought vividly various features of data privacy related
Thank
stuff.
you.
Okay, we would like to have questions, that we start with what is the role of data localization in terms of data privacy? Does it help the privacy related stuff, or
Yes.
why people are insisting data localization?
Yes. See, the control is better when they got the servers within their geography. I mean, this has been there quite long in many European countries. Now, every country that is implementing privacy law tells the data should be stored. Even the Indian PDP bill that is coming up talks about localization. And that is where there is a lot of struggle for foreign entities who are operating in India. The Indian entities, for example, people like Paytm, are able to easily comply to it, whereas other entities are not. This ensures, the data, is being stored in a physical location. They also call as the data fencing. They fence the data so that it can't move outside. So this was a practice, informally in many European countries earlier. The privacy law is mandating this. So this gives a better hold to the government in terms of holding the data within its geography. So that is the reason why they are mandating, and that is one area which is not being diluted. Many people, stick on to that till the data localization has to be done. So it becomes a mandated requirement for every country which is implementing the privacy law. So the data is with them, okay, and it's not an alien country.
Okay. In the Indian PDP bill, is there any formal definition for private data?
No, I mean, there's a formal definition which only tells the data about an individual. That's a broad guideline that is being given. Anything that could be identified to an individual, that is called as the private data.
So, but still it is subjective, that's how to interpret that. It is.
For example, the information that I hold, with that information, if I can know who is the person behind this, if I get a mobile number, then with that I can find who is the person. If I get an email ID, I can identify who is this person. If I get a car number, I'll find the owner. If I get Aadhaar card, I'll be able to know who's the individual. So with that information, if you can trace the individual, then that becomes the personal information.
See, we have been having the IT Act 2000 for quite some time.
Yeah.
Okay, now is the IT Act is not adequate for data privacy? That's the reason we're going for PDP, or how the IT Act? What will be the IT Act role when the PDP bill comes? Yeah.
See, IT Act will remain. What has happened is the penalty part of the IT Act has been moved into the PDP, Indian PDP. So the IT Act will remain. That doesn't change. But certain components of the IT Act are being moved into the Privacy Bill of India.
So, which means that the PDP bill is a subset of IT Act, right?
Exactly. Yes. In a way, it's a subset of the IT Act. Very true.
Okay. And see, we are talking about penalties. Whenever there is a breach, the company's breach are not compliant.
Yeah.
See, these penalties, who collects and then how they are utilized, apart from sharing with the people who are affected.
That's a good question. I think this is a treatment which varies from country to country. In India, of course, one is this is a question that's been going on for some time. What will the penalty be done apart from the individuals who are impacted? Okay, this could be one possibility is they're trying to improve the infrastructure for the privacy implementation. It is getting invested into the same initiative. That is one broad idea that is floating. Okay, that's what they wanted to do. Otherwise, it's held by the government. Many times, it becomes a discretion of the government to decide what they're going to do with that.
Okay. Okay. So what about the role of regulatory agency in India in dealing with global company breaching data privacy?
Huh. See, the data protection authority is being formed, but how strong they are going to be, what is the empowerment given to them, is something which we'll know only when the compromises happen. So, at least on the paper, they're going to treat the same way, either the foreign entity operating in India or an Indian corporate operating in India. So the treatment is going to be the same between these two entities. There's going to be no difference. But while this is on the paper, only when the real breaches happen, and then we see how this authority is exercising its power on these entities, only that will tell us how strong the implementation is going to be. As such, a foreign entity or Indian entity, doing the breach, they get treated the same way. There's a difference in them.
Okay. See, one of the participants has asked a very interesting question.
Uh-huh.
In the current scenario,
Yeah.
where many voice and video recordings are being shared,
Yeah.
who is the owner and how the privacy is ensured? For example,
Yeah.
this meeting is getting recorded.
Yeah.
So who owns this data? As a participant, will I also be a stakeholder?
See, in this recording, we'll just take this example. That's a good one that has come up. The personal data is more a knowledge. Okay, so not as a personal data. What could be the personal data is probably, I'll take my perspective. My name, my email ID are the ones that is going to be personal. And, I have given my consent to IEEE to, share my name. And then the knowledge is not personal data. Remember that. The knowledge comes outside this. It's only, for example, the email ID, what you see on the screen, things like that becomes personal data. In which case, either formally or informally, my consent has been given to share my information on the session. So that is already there. Same way, people who are registered for this program, even they also give a indirect consent, telling that their name can be displayed on the screen and all that. So there's sort of a consent that is available already. As an owner, obviously, from the usual days, the IP of the content will remain with the author. Okay. Whereas it is being shared with the broader audience. The IP part is separate, but on the personal data front, I give a consent to share my information on the screen. So, it is perfectly acceptable. If my information is used without my consent, then that becomes a breach.
Okay. Yeah, I think it's a bit of a tricky issue.
Yeah.
Possibly, I think if someone is making money out of this, maybe it will draw more penalty or something like that, or it may be treated as unethical, right?
Exactly. Yes.
So as long as there is no business is done with the data collected,
Ah.
and it is only used for a fair use like knowledge sharing and so on,
Exactly.
people may be exempted, right?
Yeah, very true. If it's a business, then all this applies.
Okay. And I think that one question is relating to whom the people should complain. I think that is the one which you brought in the
Data protection
DPO
authority,
concept, right?
DPO, yeah. That's the data
DPO.
protection authority. Yeah.
But something like that is going to be there in India also, right?
India also, that's right.
PDP.
Yeah.
Okay.
Yeah.
Right. Okay. And then can you briefly outline the job and consulting opportunities in this area?
Oh, yeah. Sure. See, this is becoming a hot subject. The moment the Indian PDP Act is going to be, made effective, every organization in the country should comply to the PDP. So definitely there is quite a lot of consulting opportunities that will arise, and primarily because the volume is going to be very big. Okay, could be in various scale, but as a count it is big. Okay, from a small organization to a bigger organization, this becomes mandatory, and in fact, this is a compliance which even the financial auditors will validate. When you do the financial audit, you also confirm whether you are complying to the PDP. Once it is going to be tabled and then made formal. So it's going to open up a lot of opportunities. That's for sure.
Okay. Ramkumar, can you turn your video on so that people see you?
Oh yeah, sure. 1 second. Am I visible?
Yeah, yes. I think you got the straight lights, lights are passing through. Maybe some
Okay.
background.
Yeah, sorry.
Okay. Uh, Very good. Okay. See, basically, how to get trained in this area, or only certification, or any certification, any formal courses are there also?
Yeah, see, as far as you know, I am tied up with the certifying body called Intertech. Intertech gives a DPO certification, Data Processing Officer certification. That's a 3 days course, which is also accredited by the Italian accreditation agency called Accreditia. So they also give, a certificate after they have an exam on the 3rd day, and then people who clear the exam are being given a certificate for successful clearing DPO.
Okay. See, we are getting a lot of things about dark web.
Okay.
They are the culprits, who bring the lot of data privacy. They are getting involved.
Yeah.
Is there any way that we can get protected from this dark web once this law becomes applicable?
The dark web has always been there. And whether there's a privacy law or there's no privacy law, they still keep compromising the servers. So many times these are the people who are beyond the bounds of law. Okay, you go and close a dark web, then they open something else. So that's an ongoing thing. So my point is, I don't think the dark web will ever be impacted because of the privacy law. They are criminals and they'll continue to be criminals.
Okay.
They make business out of it.
Okay. Is there any study has been done with regard to cost of compliance versus penalty?
There has been some study. I don't have the numbers with me. Definitely there are numbers published in different areas. I think even the enforcement report had some numbers on the average cost of a breach. They go into few $1,000s. That's average cost per breach. Around $3,000 to $4,000 is average cost per breach. So yeah, that's the way things are.
Okay. No. The question is regarding complaints, establishing compliance versus penalty.
Oh, I mean,
mainly to convince the top management.
Right. I mean, as would it go, the compliance requirement will be based on the risks faced with the organization. With a smaller organization, limited risk, and probably enhancing slightly existing infrastructure will suffice. But if it's a bigger corporate, you need bigger controls, better controls, things like that, and that could be at a higher cost. So the cost will depend on the organization risk profile.
Okay. Can you throw some lights on the research issues in the data privacy?
Quite a lot. I mean, I don't know for whatever reasons, at least I'm not aware in the Indian context, but there are a lot of research happening in US. Some of them even contact me. They contact me to get some inputs, how to progress for threat modeling, things like that. So people come and have, these are research students in the US. So a lot of things are happening, but I'm not aware. Something should be happening in the Indian context as well, but I'm not having visibility on that.
Okay, there have been some laws, like some acts like SOX and HIPAA and things like that.
Yeah.
What happens to those acts and then regulations? Will they continue to exist, or they are specific to certain
exactly. Yes. If you take
some
HIPAA,
domains, right? So they are specific to some domains.
Yes, some domains. So now you have to add on this privacy control into that and create an integrated model.
Okay.
One good thing is, for example, taking HIPAA and the privacy law, they don't conflict with each other. They coexist. That's advantage. So integration is easier.
Okay. And there are facilities like, you can take insurance against cyber attacks and things like that.
Yeah.
So is there anything for this Data Privacy Act? Is there any insurance?
I mean, the insurance is against the breach. So, so that already available in India. Bajaj insurance, people like that are giving cyber insurance for individuals also.
Okay. So, how these major techies, like Facebook and Google, they have been making a lot of money with our data, right? So, in terms of that, I remember every user is generating minimum $15 to Facebook or something like that.
Yeah.
Okay, so will they ever be compensating the users? Will they share some profit with the users?
I mean, that's a good question. Yeah, but maybe as the laws come, like for example, in Australia, the government is asking Facebook to pay for the news. So
Yes.
something like that may happen, but Facebook is objecting for the payment. They're not allowing accepting it. That's one issue going on. But things like that could come up going forward. Point is, what I feel is, as individuals, first the awareness that my data is being used by these entities, the Facebooks and Googles of the world. That awareness comes up, then people can start slowly, taking measures to mitigate it.
Okay. And there is a question from Professor Kaujalki regarding is there any specific rule applicable in Australia?
Yeah, they have their privacy law. Australian privacy law is there. Yes.
Because I think my feeling that Citibank or some other card operations are being handled by Australian.
Right.
Basically, I think major operations of India are being either done in Singapore or in Australia. Many of the they have their processing centers.
Right.
So and there are problems associated with this card business, like privacy.
True.
The data breach occurs in many of the card-related business. So when this happens, who will be responsible and whose penalty will be applicable? Whether Indian data being processed in Australia, which compliance will be required?
Very good question. See, so I told about the three roles. The data subject, in this case, could be the customer of Citibank. Okay, and then the data controller who happens to be Citibank, and the data process sitting in Australia. So now, when a breach happens, what is typically done is they try to deep dive, trying to see who did dilute the controls. Was it the Citibank who diluted the controls or the processor in Australia? They try to find out that, and based on the weakness they find in the system, appropriately, sometimes the penalty could be for both, for the data controller Citibank and for the processor in Australia. Or sometimes only one of them has got a major weakness, the other doesn't have, maybe the 100% penalty goes for the processor in Australia. So that percentage of the penalty is decided based on the deep dive by the authority.
Okay. So I think, but still there are, as you are mentioning, that some of the challenges, the loopholes are there.
Yes.
Particularly how it is being interpreted. Any law for that matter,
Exactly.
the interpretation takes a final judgment, is based on the interpretation, things like that.
One
so
trend,
there has to be.
Trend I've been seeing in the GDPR front is the recent penalties have been much lower than the expected ones. In fact, there was one for Boeing, where they had a penalty. They scaled down something like 80%, and 20% was the penalty, 20 or lesser percent paid as a penalty. And the reason given by the supervision authorities, they have been cooperating, they've been giving a lot of information, and things like that.
I think the largest penalty is from the British Airways. I think 180 million.
Yes.
180, I think I remember that highest penalty till now.
Yeah.
So, I think it is the subject is a really interesting one.
Yeah.
I think it provides a lot of insights.
Exactly.
But only thing is, we expect soon it becomes applicable in India. Even though there are things like DNC is there, we still every day we get minimum 15-20 calls and things like that. And there is a question of how going to be implemented, the compliance implementation and what are things. And particularly we are afraid because everywhere we are giving our PAN card details, we are giving our other details and things like that. We don't know how it will be used, misused and things like that. In fact, there are even to buy a phone, they are insisting a PAN card because it is some 20,000 rupees over transaction.
True.
It is a PAN card. As per tax authorities, sir, we have to produce the, we are making a payment by cash or something like that. This PAN card can be used and misused. Our
We
PAN
never
card
know.
can be for anywhere else.
True.
So, how in that case, how a citizen will have to prove that he was not involved in this particular episode?
I
So,
mean,
this,
yeah,
any issue comes up, so
Yeah.
then the onus is on the person who has been targeted, right?
Yeah, true. Very true.
So it becomes a very difficult for individuals, particularly when the legal awareness is so low in the country.
Yeah.
So first of all, there has to be awareness on legal issues.
Right, exactly.
Then the people have to be made known about the rights of data.
True.
And I think in India, we have a long way to go in terms of implementing these rules and regulations.
Very true.
So, thank you very much for providing eye-opener in this topic. And definitely, we have been very much enriched with our knowledge in terms of data privacy and things like that. And maybe, to create awareness.
Yeah.
And we'd like to organize few more programs. Maybe, particularly, we want to organize few programs, domain-specific programs, so that, we bring in the domain experts as well as the people, the company, even the end users involved in that particular, they get benefited. Particularly, medical field is like now the government of India has come up with a medical scheme. They are trying to implement, and everyone is going to get one more number, like Aadhaar, the medical treatment for that one more number. Like that, so many numbers are going to come. It is going to be extremely difficult for us to keep track, and then how it can be used and misused.
True. Very true.
So we'd like to have a session sometime later, and definitely we'll work out the modality, something like
That's
that.
right.
So I take this opportunity in thanking you once again on behalf of all the organizing units like IEEE, Computer Society, and CSI and ACM. So we look forward to our long-term association. Thank you.
Thank you, sir. Thanks a lot. Thank you, then.
So before we conclude our formal session, today's formal session, so there are announcements regarding our forthcoming 2 programs in the month of December. One is going to be on job before graduation. It is placement opportunities for the students, and particularly, what they have to do while studying itself. So this is going to be on 26th of this month, that is coming Saturday. And the last program for this year is going to be on 29th, Tuesday. It's going to be a really inspirational talk and how to balance spirit, mind, and body to live for a full life. So we will be ending the year 2020 with a positive note of balancing our mind and body for a long life. So with this, we would like to conclude this today's meeting, and thank you for participation, and we wish you great days ahead. Thank you.
Thanks, sir. See you. Bye-bye.
Good night.
Thanks, Mr. Ramkumar.